Welcome, everyone, to another episode of Women Winning Wednesdays. I'm your host, Maryland attorney Elsa W. Smith. I'm also the owner of the law offices of Elsa W. Smith, where our mission is to empower women through estate planning. Uh, just as a reminder, this show is streaming on Facebook, LinkedIn, and YouTube. And if you're watching us on YouTube, be sure to click the red subscribe button to ensure that you don't miss any of our videos each week. And by the way, we're growing. We have a growing YouTube community, so I invite you to subscribe and be a part of it and support the channel. So today we are going to be talking about 8 mistakes to avoid regarding beneficiary designations, and going to have good information for you today. And some of these you're probably already aware of, but it's just a good, they're just good reminders. So for those of you taking notes, 8 mistakes to avoid regarding beneficiary designations. Now, what's a beneficiary? So a beneficiary is a person or an entity who is designated, who's chosen to receive the benefits of property owned by someone else. Now, how do beneficiaries play a part of your estate plan? Well, many assets, they lend themselves to be transferred by beneficiary designation. And it's a legal designation, as I said, for somebody to receive your property upon your death. And when I say property, I'm also including proceeds, like, for example, proceeds of life insurance policies. It's a contract between you and the bank or your brokerage firm or your insurance company. And you're essentially saying, listen, if I die and somebody brings you my death certificate, I'm ordering you to distribute X amount to the people that I have designated as my beneficiaries. Okay, so that's what we're talking about. And I wanted to get that out of the way before we start talking about the 8 mistakes to avoid. So let's get right into it. The first mistake is not keeping track of all of your assets. Now, one of the reasons we as estate planners ask you to complete the estate planning intake or questionnaire is because we need you to review your entire financial picture. And listing all of the assets that make up your estate will be necessary before you decide what and how much you wish to leave to certain beneficiaries. And things we ask you about include your 401ks or 403b and other retirement accounts. We'll also ask you about individual retirement accounts, those are IRAs, Roths, SEP accounts, life insurance policies, including the ones provided by your employer, right? Bank and brokerage accounts, investment accounts, as well as 529 education plans, mutual funds, real estate, including home and any investment properties. All right. So we want to know all of that information first, right? So to get a true understanding of what your estate consists of. So the next mistake is not naming a beneficiary. Yikes, right? Undoubtedly, right? The most obvious error that you can make is failing to name a beneficiary on, say, a life insurance policy. Sometimes, however, merely designating a spouse or a child is insufficient. So here's why. So what happens if you pass away before your spouse or a beneficiary, or What if, say, you both pass away, you and your spouse, due to a catastrophic incident, right? If there is no, not only a beneficiary, but a contingent beneficiary, and we're going to talk about that in just a second. It's a backup secondary beneficiary. And the primary dies, can't be located, or say rejects that asset, the asset becomes part of your general estate and has to go through the probate process. The third mistake is, let's see, here we go, not naming contingent beneficiaries. And I just referred to that a second ago. So let me explain what a contingent beneficiary is. I guess I got a little ahead of myself there. A contingent beneficiary is designated by the owner, and that's you, say of a retirement account or an insurance contract, as the person or organization who are going to receive proceeds in the event that you, the primary beneficiary has passed away. So there's primary and then there's contingent, right? If that primary dies, refuses to accept that asset, or some other valid reason, they're just not willing to accept it, then the company refers to the contingent beneficiaries. And it doesn't matter, by the way, what your will says. What the only thing that matters, what trumps, what supersedes anything that's in your will, is what's on that beneficiary form. And you say you might choose your spouse. Here's an example. You might choose your spouse as a principal beneficiary of like 100% of the account when deciding, who's going to inherit your assets. If your spouse passes away before you do, and your two adult children, if you have two adult children in this hypothetical, would receive 50% of the estate as, contingent beneficiaries, if that's how they're named. Additionally, you might designate your spouse as a principal beneficiary of, say, 50% of the account, with your children receiving 25% each in that hypothetical. So you can even designate, and I've been asked about this a lot just recently, you can designate a nonprofit, a charity, as a beneficiary. However, you really should consult a tax expert about the best method of going about doing that. The key here is that you're free to allocate your assets any way you see fit, but make sure to connect with a tax professional and work with an estate planning attorney in helping you craft that. Number 4, the fourth mistake, is naming a minor child as your beneficiary. Oh my goodness, this is one that I see so often. Okay, life insurance will take care of children, and a lot of times, parents say, well, I wanted to have a life insurance policy and I'm doing it for the benefit of my child. However, designating children as beneficiaries isn't smart. Here's why. Direct life insurance benefits from insurance companies are not available to minors. Okay, if you purchase a life insurance policy for minor children without establishing a trust, for example, the court's going to have to appoint a guardian to handle those proceeds. So in that situation, it's preferable to create a trust and name the trust as the policy's beneficiary. So, keep that in mind, please. And that's actually one of the first things that I talk about with my clients when they become members of or clients of the firm, is in that initial review of beneficiaries, I ask, are there children named? And so we need to update that immediately. Fifth mistake is not updating your beneficiaries. Now, here are just a couple of disasters that can occur by not keeping your beneficiaries current. Okay, so young people, a young couple just starting out in their professional careers may name their parents as the first beneficiaries. However, life happens, and if they get married, they'll probably want to change that beneficiary to their spouse, and eventually, to a trust for the benefit of children. Now, if they don't do this, right, they just neglect to update the beneficiaries, those benefit payments are going to go to their parents. And if their parents are no longer alive, that's really a mess. That's really going to complicate things significantly. Here's another example of what can happen when you don't update your beneficiaries. And this is what I've said in other videos. I call it the nightmare scenario. And it deals with marriages and divorces. And unfortunately, not all marriages last. And after divorce, updating your beneficiaries is probably not at the top of your priority list. However, if you remarry, or you just decide to remain single, your beneficiaries don't automatically update, right? So without giving that updated information, it's possible that your ex will receive the benefits of of your life insurance instead of members of your new family. If you remarry, um, again, the nightmare scenario. The ex ends up with $1 million. Your current spouse, if you remarry, gets nothing. So let's not do that, please. Number 6 is naming a beneficiary who has special needs. Now, you run the risk of unintentionally disqualifying an adult or a child with special needs who is or may become eligible for government benefits by designating them as a beneficiary. Instead, you would want to consider a special needs trust and designating it as the beneficiary. Then number 7 here is using your will, or trying to use your will really, to change beneficiaries. And here's what I mean. Don't make the mistake of believing that you can just, even though I'm beating that drum and telling you to update your beneficiary forms with each one of the companies that you're associated with, don't make the mistake that you can just change your beneficiaries by naming someone else in your will to receive that money. A properly executed beneficiary designation document will always prevail over a will. Let that sink in. So only the assets in your name, excuse me, without co-owners, with a right of survivorship, or without designated beneficiaries are governed by the will. So again, it's really important at the outset that you get an understanding of all the assets that you own. Secondly, check the beneficiaries of all policy documents. And then as you're working with your estate planning attorney to either create or update your will, you want to have those documents to make sure that there's synchronicity there, right? We certainly don't want to have that kind of conflict, because that's frustrating your ultimate goals of how you want to distribute your assets. So that's why it's really important to be aware of what the current beneficiary designations are, and then balance that again, compare that against the estate plan that you are this estate, excuse me, the estate planning documents that you're having your estate planning attorney prepare for you to make sure that there is synchronicity. Okay. And then number 8, as we're winding down here, is ignoring the financial impact on on beneficiaries. Um, Adult children may not be prepared. Let's be frank. They may not be able to handle a large inheritance for a variety of reasons. They may be financially immature and unable to, budget their finances. They could be in an unhealthy relationship where they have little say or control over their financial affairs. They may be unable to cope due to addiction issues. They could also be too young, and in many cases, um, giving a large sum of money to an heir can have disastrous consequences. So the truth is that some people are just simply unprepared to deal with receiving a large sum of money. So in those types of situations, you'd want to consider what's called a spendthrift trust. And I want to spend a moment on that because not a lot of people know that it exists and that it is an option that you can incorporate within your estate plan. So just a little aside here, a spendthrift trust protects your heirs from themselves, quite frankly, by granting a trustee, a person you designate, a trusted person, um, the authority to control how the funds are used for the benefit of that beneficiary, if it's your adult child or whomever. But we're using adult child for the sake of this example. Then you, as the creator, include specific language indicating that the trust, qualifies as a spendthrift trust, and limitations on the beneficiary's control of the funds. So then the trust really does become a spendthrift trust. So it can provide a specific amount distributed to that beneficiary monthly, quarterly, or yearly, right? Annually. It can permit for additional distributions when a beneficiary reaches a certain age or a certain stage in life. Maybe when they graduate from college, maybe upon the purchasing of a home or so, or when they reach the age of 35 or 40, for example. You can also identify specific types of expenses for which the trustee can make distributions. Examples, have been or are college tuition, down payment on a home, major medical expenses, etc. And that trust can last for a set period of time or until the beneficiary reaches a certain age. And at that point, then anything that's left in that trust is then distributed to the beneficiary. Okay, so those are examples of terms that you can include in your spendthrift trust. It also protects assets from creditors, creditors of the beneficiary. Let me be clear on that, because the beneficiary doesn't own the assets directly. The trust is the owner of those assets. And it can also, a good thing about the spendthrift trust is it can also keep money away from manipulative family members and friends. And then you have to question, are they really friends if they're manipulating a beneficiary to do something against their best interest? So we've talked about the 8 mistakes that you can make regarding 8 mistakes to avoid, quite frankly, regarding beneficiary designations. It's important that your estate plan is reviewed by an estate planning attorney. And many people are just frankly unaware that beneficiary forms take precedence over wills. I've said that before. I want to say it again, drive that point home. They can spend time and money creating a will that outlines, their intentions, only to learn that the majority of their assets are being distributed by other means, which may not be in alignment with the estate plan that they've created. So I want you to just make sure that all of your assets have the appropriate beneficiary designation language and they're properly titled. Your preferences about the division of your assets upon your death, you know that is the ideal way, that is the best way to make sure that your wishes are honored. So I hope that you have gotten a lot from this episode, and play it back, share it. Again, we're airing this is streaming live on YouTube. Be sure to click that red subscribe button to become a member of our growing YouTube community. And let us know what you think. Do you want to see more episodes like this with this information? For some of you who've been following me for a while, a couple, maybe one or more of these tips because I've raised them in other videos. But for the vast majority of people, they have no idea. Why do I know this? Because we get calls to the office about these sorts of issues, and they come up when people come to see the firm for a consultation. So I hope this is of value to you. Keep it in, download the videos, share them as you deem appropriate. And I want to thank you for joining us for another episode of Women Winning Wednesdays. If you're in Washington, D.C. or the state of Maryland, I want to invite you to give us a call. Follow us on social media. The number to the office has been scrolling at the bottom of the screen since the beginning of this episode. Set up a consultation, reach out to us. We are here to serve as your trusted partner as you're moving forward in creating, one of the most important documents that, you as an adult will create, and that is your estate plan. All right. So have a wonderful day, everyone. Thank you for joining us on another episode of Women Winning Wednesdays. I'll see you soon. Be well.